5-day hearing looking into Israel's humanitarian obligations in the occupied Palestinian territories as an occupying power. These are live pictures from The Hague. The judges on the bench have just come in. Member states have raised concerns that humanitarian work in Gaza is in danger of collapse because of Israel's actions. Israel has banned all cooperation with the UN agency for Palestinian refugees, known by its acronym UNRWA. Members of that agency have been killed in Israeli attacks on Gaza. UN-run facilities across the Strip have been bombed and destroyed. UNRWA is the main provider of food and schooling and medical services in Gaza. Well, as the session gets underway, we're going to have live coverage of that over the next few hours. Rory Challands is going to be live for us from The Hague. He's joining us now. Rory, just talk us through more of the context, first of all, to these hearings that are beginning today.
Yeah, well, the background to this whole event is a UN General Assembly resolution that was brought last year by Norway and a group of other countries who basically asked the ICJ to come to some sort of opinion on whether Israel, as a signatory to the United Nations Charter, acted unlawfully in overriding the immunities afforded to a UN body. Now, that sounds fairly mealy-mouthed, but what it comes down to is, does Israel's treatment of UNRWA, the UN agency that looks after Palestinian refugees, does that adhere to its obligations, its humanitarian obligations? At issue, basically, are two bills that passed in the Israeli Knesset last year in October that declared that UNRWA harboured Hamas terrorists, as they put it, and instructed the Israeli government to end all cooperation and contact with the organisation, including the supply of visas to UNRWA international staff, which has had a huge impact on the flow of food and aid into the besieged Gaza Strip. Now, 5 days of hearings is going to go on for the whole week, and at the end of that, we are then going to have to wait perhaps several more weeks before we find out what the judges are concluding from all this. Over the course of the 5 days, we are going to hear from numerous different countries, 40 plus countries, including the United Nations and including other international bodies and federations, all of whom are going to be giving their opinions to the judges. Now, it is likely that it's going to be not until Wednesday that we actually hear from any country that is going to be supportive of Israel. That's when the United States is speaking, and that's when Hungary is speaking. But largely, we're expecting that most of the countries that are going to be delivering their opinions in the court over the next few days are going to be critical of Israel. What do we get at the end of all of this? Well, what we will have is a non-binding advisory opinion from the International Court of Justice that basically will likely be ignored by Israel, as it has done other judgments from the International Court of Justice, as it has done towards the International Criminal Court and other international legal bodies as well. So what does this all mean? Well, yes, it may sound like a non-binding advisory opinion is fairly wishy-washy, but it will likely have an effect because it does add into this growing essentially body of decisions in international courts that Israel is in contravention of various international obligations and international laws. And that sets the tone, doesn't it? It's the context, the framework by which countries around the world deal with Israel, and the tide, the pressure is mounting on them.
Rory, for now, thank you very much indeed. And of course, we're going to be coming back to you as the hearings get underway. While we're looking at the pictures, let's dip in and just find out where we are in the proceedings. This is predominantly at this stage, essentially procedural. Let's listen in.
Information on the question submitted to the court for an advisory opinion and fixed 28 February 2025 as the time limit within which written statements on the question might be presented to the court in accordance with Article 66, paragraph 2 of the statute. Pursuant to Article 65, paragraph 2 of the statute, on 30 January 2025, the Secretariat of the United Nations communicated to the court a dossier of documents likely to throw light upon the question formulated by the General Assembly. Additional documents were transmitted to the court under the same provision on 10 February 2025, 20 February 2025, and 19 March 2025. The complete dossier has been published on the court's website. Ruling on requests from the Organisation of Islamic Cooperation, the League of Arab States, and the African Union, the Vice President, Acting President, decided, in accordance with Article 66 of the statute, that those three international organizations were likely to be able to furnish information on the requests submitted to the court. They were therefore authorized to submit written statements within the time limits fixed by the President of the Court and participate in the oral proceedings. They were also informed that the dossier of documents communicated by the Secretariat of the United Nations had been posted on the court website. By communications dated 6 February 2025, the registry informed the United Nations, its member states, and the observer state of Palestine, as well as the international organizations authorized to participate in the proceedings, that the court had decided to hold public hearings on the question for an advisory opinion, which would open on 28 April 2025. The addressees were further invited to inform the registry by 17 March 2025 if they intended to take part in those hearings. Within the time limit of 28 February 2025, written statements were filed in the registry by 41...
It is 8:10 GMT and you're watching Al Jazeera. These are live pictures from The Hague. This is the beginning, the opening of a 5-day hearing at the International Criminal Court at the behest of 45 countries and organizations, including the UN itself, requesting an advisory opinion from the 15-strong judging panel on Israel's actions with regards to its banning of the UN's Palestinian Rights Agency, UNRWA. They are saying that that is a breach of the UN Charter, which Israel has signed. Now, we're going to be hearing evidence over the next 5 days from a variety of different organizations and countries, as Rory Challands was just explaining to us, in support of those allegations. Israel has submitted a written defense, we understand. It's not due to make oral submissions this week. It is a test of Israel's defiance of international law, because the ICJ's landmark ruling in January, March and June of 2024 that ordered it to take immediate steps to allow aid to enter Gaza unhindered appeared to have gone ignored to a great extent by Israel. Israel has largely refused to comply with advisory orders attached to the rulings from the ICJ. And that, of course, has added to the crisis of confidence, critics say, of the ICJ in the credibility of the international legal system. We're going to be covering this over the coming hours and days. For now, we're going to go to Tariq Abu Azum, who's live for us in Al-Nusayrat in central Gaza. Talk to us about the impact that Israel's actions that they're talking about in The Hague there have had on the daily life of people in Gaza.
Well, Rob, the Israeli systematic escalation that is still taking place in Gaza has led to severe repercussions on different life aspects. And apparently one of these repercussions that we have seen getting much more gravely on the ground is the decision to cease cooperation with UNRWA here, as UNRWA has been seen by Palestinians in Gaza as not just an aid organization operating in the territory, but a very fundamental lifeline that provides different services in multiple aspects, including education, healthcare, alongside also with the emergency food services provided for millions of Palestinians in the territory. For many Palestinians here, they see see the hearings in the ICJ today as a very good opportunity and a clear strategic chance in order to pressure Israel and to protect and to ensure the legal protection of the afforded to the UN agencies in Gaza in order to enable the world to understand better that UN agencies have been operating to alleviate the crisis and to challenge the actions that have been adopted by Israel that led to significant deterioration in terms of the humanitarian crisis on the ground. For many families, for many Palestinians, without UNRWA, their life will be pushed into more cycle of despair and more critical circumstances that cannot be easily treated. At the background is one of the key central sanitation centers that had been run by UNRWA here. UNRWA did not just only run sanitation services for Palestinians, but also they have turned the vast majority of their schools and clinics to be emergency shelters for families, and people believe that UNRWA was created to serve the Palestinian refugees, believing that no UN body or any other NGO has a mandate to uphold the Palestinian rights and the refugee status due to the fact that no significant and just political solution is found. So apparently the Israeli acts on the ground have heavily impacted UNRWA's operations, and Israel has repeatedly accused UNRWA of different accusations related to UNRWA's infiltration by Hamas. This accusation and allegation has been met by international skepticism and demands by the global community to provide more concrete evidence regarding this, but nothing has in fact been presented so far. So the Israeli acts, Rob, in Gaza have led to a clear destruction of all life aspects, and now with the Israeli potential step to eradicate UNRWA from the territory, it means that Palestinian refugees will become increasingly and politically invisible, which means that there's going to be a full elimination for the right of return, and this multi-dimensional political and historical link with the case of refugee will be absolutely erased forever if this step will be successfully implemented.
Tariq, for now, thank you very much indeed. Tariq Abazoum talking to us there from Al-Nusayrat in central Gaza. Let's go back to The Hague and listen in to some of the proceedings.
There is an urgent need to return to a ceasefire and for the parties to respect their obligations under international law. The Secretary-General has consistently reiterated his strong and unequivocal condemnation of the abhorrent acts of terror by Hamas and other Palestinian armed groups on 7 October 2023. He has also repeatedly called for all the hostages to be released immediately and unconditionally. No humanitarian aid or commercial goods have been allowed into Gaza since the 2nd of March, which has devastating humanitarian consequences in the Gaza Strip. The Secretary-General continues to call for humanitarian aid to reach all people in need. As I stand before you, 295 United Nations personnel have died in Gaza since the 7th of October 2023. Mr. President, the request in General Assembly Resolution 79232 that the Court render an advisory opinion focuses on the obligations of the State of Israel. This statement will therefore do likewise. Before doing so, I want to reiterate that all parties to a conflict must comply with all their obligations under international law, including international humanitarian law and international human rights law at all times. In the context of the situation in Israel and the occupied Palestinian territory, Israel, the State of Palestine, and non-state actors, including Palestinian armed groups such as Hamas, have obligations under international law that must be observed.
Mr. President, members of the Court, the purpose of this oral statement is to assist the Court in the present advisory proceedings concerning the obligations of Israel as occupying power and member of the United Nations, with regard to the presence and activities of the United Nations in and in connection with the occupied Palestinian territory. The United Nations has a special and direct interest in these proceedings. Detailed information has already been provided in the written statement on the presence and activities of the 13 United Nations entities in the occupied Palestinian territory. So I will not repeat that information today. I shall confine myself to pointing out that all these entities are subsidiary organs of the United Nations within the meaning of the Charter, or form part of the United Nations Secretariat. In this respect, I would stress that the status of these entities is irrefutable. These entities are engaged in the unhindered supply of basic necessities essential to the survival of the Palestinian civilian population. Also, in some cases, these entities are engaged in the provision of basic services and humanitarian and development assistance in the interest of the Palestinian civilian population and in support of the right of the Palestinian population to self-determination. Today, I will present my remarks as follows. First, I will refer to Israel's obligations as the occupying power, and second, I will refer to Israel's obligations as a member of the United Nations.
Members of the Court, I will now elaborate on the obligations of Israel as an occupying power. After making initial preliminary remarks, I will turn to three specific issues. First, the scope of relief schemes under the Fourth Geneva Convention. Second, the limitations on the authority of the occupying power to administer an occupied territory. And third, the protection of humanitarian, medical, and United Nations personnel in general. Israel has several obligations in relation to the presence and activities of the United Nations in the occupied Palestinian territory by virtue of its status as the occupying power. These obligations include the following obligations under international humanitarian law: the overarching obligation to administer the territory for the benefit of the local population, the obligation to agree to and facilitate relief schemes, the obligation to facilitate the proper working of all institutions devoted to the care and education of children, and the obligation to maintain the medical and hospital establishments and services, including those set up by United Nations entities. In the specific context of the current situation in the occupied Palestinian territory, these obligations entail allowing and facilitating all relevant United Nations entities to carry out those activities for the benefit of the local population. In addition to international humanitarian law obligations, international human rights law obligations are also applicable to the conduct of Israel with regard to the occupied Palestinian territory. This includes respecting the decisions of the representative of the Palestinian people to receive basic goods and services from the United Nations entities in order to fully enjoy their right to self-determination. Israel is bound to respect the decision of the Palestinian people on the manner in which the dependence of the West Bank, including East Jerusalem and Gaza, on Israel for the provision of basic goods and services should be reduced. Israel has the obligation to render assistance to such activities of the United Nations. Mr. President, members of the Court, against this background of an overarching framework, I would like now to move specifically address 3 points of international humanitarian law. First, I would like to address the scope of relief schemes under Article 59 of the Fourth Geneva Convention. I recall that under Article 59, the occupying power is required to agree to relief schemes and facilitate them if the whole or part of the population of an occupied territory is inadequately supplied. Article 59 refers to relief schemes in general. The plain terms of Article 59 do not limit relief schemes to objects that are urgently needed for the survival of the civilian population. Article 59, paragraph 2, specifically refers to foodstuffs, medical supplies, and clothing. These are examples of relief supplies and do not constitute an exhaustive list of objects that constitute relief schemes. The content of relief schemes depends on the needs of the population of an occupied territory. The legal obligation covers those needs that have to be addressed immediately. For example, when a large number of population is displaced due to military operations, relief schemes would comprise items that are essential to address their immediate needs, such as food, water, shelter, and hygiene facilities. The definition should also be understood to cover needs which may be more long-term, in particular in cases of prolonged occupation. For example, relief schemes to address long-term needs may include items that are essential for the construction and repair of certain infrastructures, including medical and sanitation facilities, and items and services to eradicate poverty. Therefore, the needs of the population in an occupied territory could evolve depending on the nature and duration of the occupation, and relief schemes need to be adapted to the evolving needs. The occupying power must agree to such relief schemes as adapted and facilitate them. Second, the authority of the occupying power to administer an occupied territory must be exercised in a manner that is consistent with international humanitarian law. Any measures taken by the occupying power to ensure its security must be exercised in a manner that would not deny impartial humanitarian organisations, such as the United Nations, the ability to carry out relief schemes, while part of the population of an occupied territory continues to be inadequately supplied. In instances where the occupying power has concerns with the impartiality of a humanitarian organisation, the occupying power may not unilaterally declare that such humanitarian organisation is not impartial and deny its relief schemes. Such concerns must be addressed in consultation with the humanitarian organisation concerned. I will elaborate on this point later. Third, under international law, including international humanitarian law, humanitarian relief personnel, medical personnel, and United Nations personnel must be respected and protected. As such, attacks may not be directed against such personnel as long as they are entitled to the protection given to civilians under international humanitarian law. At every stage of the conduct of military operations, all feasible precautions must be taken to avoid, and in any event to minimise, incidental casualties to humanitarian, medical, and United Nations personnel. They must be treated humanely and must not be subjected to harassment or intimidation. They are also protected by international human rights law. As such, they must not be subjected to arbitrary arrest or detention. United Nations personnel, including those who carry out humanitarian and medical work for the United Nations, are also accorded particular status under the Charter of the United Nations and the Convention on the Privileges and Immunities of the United Nations, to which Israel is a party. Consistently with their status as United Nations officials or experts, United Nations personnel may not be attacked, arrested or detained, or subjected to any form of legal process in connection with their official functions. Privileges and immunities are granted to United Nations personnel in the interests of the organisation. Interference with their functions impedes the activities of the United Nations as an organisation. Mr. President, members of the Court, I will now move on to the second part of my statement, which concerns Israel's obligations as a member of the United Nations. I will start by recalling the unlawfulness of Israel's continued presence in the occupied Palestinian territory and the relevance of this to the present proceedings. I will then recall the general obligations arising from the Charter and the 1946 Convention on the Privileges and Immunities of the United Nations, which I shall refer to in my statement as the General Convention. I will then specifically discuss, first, the inviolability of United Nations premises, second, the general obligation of cooperation with the United Nations, and third, the issue of impartiality of certain United Nations entities. Mr. President, members of the Court, I will now turn to the first point, the unlawfulness of Israel's continued presence in the occupied Palestinian territory and the relevance of this to the present proceedings. Under international law, states, including members of the United Nations, are prohibited from acquiring territory by force. In the advisory opinion of 19 July 2024, this court concluded that Israel's assertion of sovereignty over and its annexation of certain parts of the occupied Palestinian territory constitute a violation of the prohibition of the acquisition of territory by force. On this basis, the Court has authoritatively determined that Israel is not entitled to sovereignty over or to exercise sovereign powers in any part of the occupied Palestinian territory on account of its occupation. The enactment of the law to cease UNRWA operations and of the law to cease UNRWA operations in the territory of the State of Israel by the Knesset of Israel on 28 October 2024 appears to constitute an extension of sovereignty over or exercise sovereign powers in the occupied Palestinian territory, including East Jerusalem. The same can be stated regarding any measures taken on the basis of those laws and other applicable Israeli law in the occupied Palestinian territory, including East Jerusalem. They are, as such, inconsistent with Israel's obligation under international law. Insofar as the law to cease UNRWA operations in the territory of the State of Israel, among other effects, prevents UNRWA operations in East Jerusalem, which Israel considers to be part of the territory of the State of Israel, the enactment and implementation of this law is also inconsistent with the international legal status of East Jerusalem. I will now turn to certain general obligations under the Charter. The present proceedings are crucial because they will afford the opportunity to clarify certain fundamental elements of the legal framework applicable to the United Nations. The status of Israel as a member of the United Nations entails several legal obligations concerning the presence and activities of the United Nations in and in relation to the occupied Palestinian territory. These obligations are all essential for the organisation to properly function and perform the mandates it has been entrusted by its member states. The exclusively international character of these functions and mandates is enshrined in Article 100 of the Charter. When the basic elements of this legal framework are not observed, the very nature of the work of the organisation on behalf of its member states is in jeopardy. The basic elements of the legal framework of the United Nations include general principles of good faith and cooperation with the organisation, obligations concerning the safety and security of United Nations premises, property, assets and personnel, and more specifically, obligations concerning the privileges and immunities of the United Nations and its premises, property, assets and personnel. Regarding these, I wish to note that the Charter confers certain privileges and immunities to the organisation so that it may fulfil its purposes, as Article 105 of the Charter makes clear. Such privileges and immunities are applicable to all entities that are integral to the United Nations, including its subsidiary organs such as UNRWA, which was established by the General Assembly as its subsidiary organ. In the written statement of the Secretary-General, the obligations stemming from the Charter and from the General Convention were elaborated in detail. These principles are well set in law and practice. In this regard, I welcome the fact that a clear majority of member states, having submitted written statements, appear to agree on the importance of the privileges and immunities of the organisation and its personnel. Today, I wish to underline, before turning to certain specific points, the importance for United Nations operations of the obligation to uphold the immunity from legal process of the United Nations and its personnel, irrespective of which United Nations entity they may be assigned to. Equally important is the obligation to facilitate the movement of supplies, goods and equipment of the United Nations and the freedom of movement of its personnel. Particularly since the end of January this year, United Nations operations on the ground, specifically for UNRWA, have faced increasingly difficult conditions. Following the enactment and implementation of the Knesset laws, the issuance of visas to UN personnel has been further denied or restricted, and actions have been taken against UNRWA personnel in connection with their duties for the organisation. There has been unauthorised entry into UNRWA schools, and orders for their closure have been issued, notwithstanding the ongoing mandate for UNRWA activities. In this regard, it is necessary to uphold the privileges and immunities of the United Nations and its personnel. As set out in documents contained in the dossier provided to the Court, violations of these obligations have occurred. Differences arising out of the interpretation or application of the General Convention may result in a situation in which a difference under the General Convention has arisen between the United Nations and Israel. Mr. President, members of the Court, I would like now to elaborate more specifically on 3 points. First, I wish to emphasise the absolute and mandatory obligation to respect the inviolability of United Nations premises, property and assets at all times, including during armed conflict, in accordance with international law. Article 2, Section 3 of the General Convention provides that the premises of the United Nations will be inviolable. Also, that property and assets of the United Nations, wherever located and by whomsoever held, shall be immune from search, requisition, confiscation, expropriation, and any other form of interference, whether by executive, administrative, judicial, or legislative action. Consistently with this provision, inviolability entails that state agents may not enter or otherwise physically penetrate or physically interfere with the United Nations premises without the prior consents of the United Nations. It also entails a duty on the part of the state to take all appropriate measures to prevent the United Nations premises being entered or otherwise physically penetrated, damaged, or interfered with by other actors. State officials, including members of the armed forces and domestic law enforcement authorities, may not enter United Nations premises without authorization by the United Nations. Any other form of interference is also prohibited by Article 2, Section 3 of the General Convention. These obligations, therefore, also prohibit any state authorities, including a state's armed forces or security forces, from hitting, damaging, or attacking United Nations premises, property and assets. There are no stated qualifications to or limitations on inviolability in the General Convention and other relevant agreements. There is no reference to inviolability being merely functional in nature, as is in the case for certain other provisions in the General Convention. Nor is there any reference in the General Convention to situations of armed conflict, civil unrest, or other emergency situations as constituting possible limitations on such inviolability. The respect for the inviolability of United Nations premises, property and assets is an indispensable precondition for the organisation to be able to implement its mandated activities all over the world, including in the occupied Palestinian territory. Serious breaches of international law have been committed by parties to the ongoing conflict, but a breach by one party does not excuse breaches by other parties. I will now refer to the second point, the general principles that enshrine obligations of cooperation with the United Nations. It is from the preamble of the Charter that we derive the notion that member states have committed to combining their efforts to accomplish the aims of the organisation. Among the principles set out in Article 2 of the Charter is that all members, in order to ensure to all of them the rights and benefits resulting from membership, shall fulfil in good faith the obligations assumed by them in accordance with the present Charter. Another of the principles is set out in Article 2, paragraph 5 of the Charter, which requires in its first part that all members shall give the United Nations every assistance in every action it takes in accordance with the present Charter. Consistently with the Court's interpretation of Article 2, paragraph 5 of the Charter in its advisory opinion concerning reparation for injuries suffered in the service of the United Nations, in the practice of the Secretariat, Article 2, paragraph 5 of the Charter has generally been interpreted as meaning that member states are required to provide every assistance to the United Nations entities to ensure the effective implementation of their mandates. In this context, it has been generally relied upon when calling upon states to comply with their obligations under Article 105 of the Charter and the General Convention. In the present case, the United Nations action consists of the activities carried out by a number of United Nations entities in the occupied Palestinian territory. Such activities are carried out consistent with resolutions of the Security Council and the General Assembly, and with mandates provided by various United Nations bodies, in a context in which this Court has authoritatively held that Israel is not entitled to sovereignty or to exercise sovereign powers. In these circumstances, Article 2, paragraph 5 of the Charter is directly relevant in the context of Israel's responsibilities vis-à-vis the presence and activities of the United Nations in and in relation to the occupied Palestinian territory, in accordance with international law, including other provisions of the Charter. Finally, my third point, referred to in certain written submissions, relates to allegations that have been raised as to the impartiality of certain United Nations entities. The United Nations considers very seriously any credible allegations against the organisation, including those involving its personnel or misuse of its premises. Any such concerns must be brought to the attention of the organisation so that the matter may be considered by the United Nations in accordance with its legal framework, including the privileges and immunities of the organisations and its personnel. The organisation has established a framework to address and investigate specific allegations of incidents brought to its attention, which is in line with the status, privileges and immunities of the UN. With regard to allegations against United Nations personnel, the regulatory frameworks of the United Nations require such allegation to be confirmed through an internal administrative investigation, which may include referring the allegations to the Office of Internal Oversight Services, OIOS, for investigation. The ability of the United Nations to further inquire into allegations depends on the full cooperation of member states, including the provision of relevant documents and materials, without which the organisation may not have sufficient basis to take further action in specific cases. Where concerns relate to broader issues, the organisation has taken further steps to review the matter. For example, following allegations that have been raised against UNRWA and its personnel, UNRWA and OIOS have taken steps to investigate those allegations in line with the organisation's regulatory framework and continue to do so. In response to Israel's concerns regarding the neutrality of UNRWA personnel more broadly, the Secretary-General appointed the former Foreign Minister of France, Catherine Colonna, to lead an independent review to assess whether UNRWA was doing everything within its power to ensure neutrality and respond to allegations of serious neutrality breaches when they are made. The Secretary-General and UNRWA have expressed their commitment to fully implementing the review's recommendations with the support of Member States. We note that such steps have been welcomed by the General Assembly and by a number of Member States in their written submissions for these proceedings.
Mr. President, members of the Court, I conclude by recalling that Israel continues to launch devastating strikes on Gaza, strikes that have continued to claim the lives of hundreds of civilians, including United Nations personnel. Furthermore, no humanitarian assistance has been allowed into the Gaza Strip since early March. As a result, the Secretary-General has taken the difficult decision to reduce the organization's presence in the Gaza Strip, even as humanitarian needs are increasing dramatically and our concern for the protection of civilians is growing. The United Nations is determined to carry out its mandates in the occupied Palestinian territory, including Gaza, in particular by providing civilians with the assistance they need to ensure their survival. In order for United Nations entities carry out their functions, all parties to the conflict must fully respect their obligations under international law, including the obligation to protect the absolute inviolability of United Nations premises and the obligation to ensure respect for the independence and status of United Nations personnel. In this regard, Israel's compliance with its obligations under international law is essential for the United Nations entities to carry out their mandates in and in relation to the occupied Palestinian territory. Such respect for international law is equally essential for the protection of civilians, and so that our colleagues at the United Nations can continue to work to save civilian lives without facing intolerable risks. Respect for international law by all parties remains the only option for lasting peace, as well as for the security and justice of Israelis and Palestinians. Mr. President, members of the Court, thank you for your attention.
I thank Ms.
You're watching Al Jazeera. We're bringing you live coverage of a hearing at the International Court of Justice. It started a 5-day hearing, actually, into the position of Israel with regard to UN agencies, particularly the Palestinian Rights Agency, UNRWA. Israel has banned all cooperation with UNRWA, and the allegation is that that is a breach of the UN Charter, which Israel has signed. This is the representative from Palestine.
to present Palestine today and its proud people in these proceedings at a time of existential crisis for the Palestinian people and for the rule of international law. On behalf of Palestine's delegation, I wish to congratulate you, Mr. President, on your election as President of the Court and to wish you success in your tenure. Allow me also to express our gratitude to the courts holding these hearings on an expedited basis. As I address you today, the Palestinian people are being starved, bombed, and forcibly displaced by Israel, their unlawful occupier. Israel has not allowed food, water, medicine, and medical supplies or fuel into Gaza for the past 2 months, a policy supported by the highest court in Israel, which rejected petitions to allow aid into Gaza on several occasions. This man-made catastrophe of unprecedented proportions targets life itself. Death looms large, including by starvation, which has already claimed the lives of 59 Palestinian children. The UN Secretary General has described Gaza as a killing field, where civilians are in an endless death loop. Mr. President, we are here today because the General Assembly asked the Court to determine the legal obligations of Israel in relation to the provision of urgently needed humanitarian assistance by the United Nations, other international organizations, and third states, and in relation to the exercise of the right of Palestinian people to self-determination. This request was provoked by the international community's outrage at Israel's methodical targeting, banning, and obstructing of said parties, including its legislation banning the United Nations Relief and Works Agency of Palestine Refugees, UNRWA, from fulfilling its UN mandate in the occupied Palestinian territory, including East Jerusalem. There can be no doubt about the Court's jurisdiction in these proceedings. The question raised by the General Assembly is plainly a legal one. It specifically asks the Court to advise on Israel's legal obligations under international law and other rules of international law. Nor is there any reason, let alone a compelling one, for the Court to decline to answer it, as the Court has already determined in 2 prior advisory opinions. The question of Palestine is fundamental to the United Nations and its mandate in this case. This request was provoked by the international communities. During this presentation, the State of Palestine will present evidence on the devastating immediate, intermediate, and long-term consequences of this unlawful Israeli policy on Palestine and its people, on every aspect of their fundamental rights and continued existence. The State of Palestine will also present the Court how Israel's prohibited conduct extends to the occupied West Bank, including East Jerusalem, because the target of these actions, by admission of top Israeli leaders, is the permanent annexation of the Palestinian territory and the ethnic cleansing of Palestinians. It is a self-incriminating admission that debunks the security sham they used to justify their genocide, as we will also demonstrate in our presentation. Mr. President, members of the Court, before I go any further, allow me to first address the context in which these deliberations are happening. This legal and moral crisis is not 18 months old. Israel has been systematically dispossessing, uprooting, slaughtering and imprisoning Palestinians in absolute flagrant disregard for international law and the inalienable rights of the Palestinian people for 8 years now. It has done so with the intent to destroy our people and to thwart the realization of self-determination in their homeland. To implement this policy, Israel has waged a relentless campaign of erasure against Palestinian people, their demography, their material presence, their national identity, their history and heritage, and their very humanity. This campaign of erasure was a central hallmark of the Nakba that started in 1947, and whose darkest chapter yet unfolding before our eyes and yours. On 3 separate occasions in the past years, the court issued provisional measures ordering Israel, among other things, to ensure and facilitate the unimpeded flow of humanitarian assistance into Gaza. Israel did not comply. On 19 July 2024, this court also ruled that Israel's presence in and control over the occupied Palestinian territory is unlawful and must come to an end. The court also ruled that despite the illegality of occupation regime, Israel was still bound by its obligations under international law as an occupying power. These obligations include ensuring the welfare of the protected civilians. Israel defied this ruling and the rule of law, brazenly declaring instead its official policy of annexing the occupied Palestinian territory, forcibly displacing Palestinian people, weaponizing food and humanitarian aid, and negating refugee issue and their rights, including by banning UNRWA. On 21st of November 2024, the ICC issued arrest warrants for the Prime Minister of Israel and now his former Minister of War, in part because they intentionally deprived civilian population in Gaza of food, water, medicine, and other essentials. To summarize, Israel is an unlawful occupying power, standing trial for genocide. Its Prime Minister is wanted by the ICC. It's attempting to destroy Palestinian people and erase Palestine, including by barring and obstructing humanitarian organization, thus also violating its obligations under the UN Charter and other instruments of international law. That is the context of the question before you. Mr. President, members of the court, UNICEF says Israel's onslaught has killed and injured 100 Palestinian children in Gaza every day since 18 March 2025. This is in addition to the more than 15,000 children Israel has killed since the onset of genocide, and the thousands who are still missing under tons of piling rubble of what was once their schools and their homes. Israel's genocidal campaign has turned Gaza into the home of the largest cohort of child amputees per capita in the world. Their limbs are amputated without proper medicine or care.
You're watching Al Jazeera, and we're bringing you live coverage of a hearing that has begun at the International Court of Justice into Israel's ban on all cooperation with the UN's Palestinian Rights Agency, UNRWA, claiming it is a breach of the UN Charter, which Israel has signed. We've just been hearing from Amar Hijazi, the Palestinian ambassador to the Netherlands. He's presenting the Palestinian representative's case in support of the allegations that are being put forward in front of the court.